Good afternoon, everyone. My name's Jeremy Streten, and I've got with me Craig Mason, and welcome to Streten Masons Lawyers' second webinar in the series about accountants and the legal update. If anyone can't see the slides, if you could just send us a message in the chat box, that'd be good, and we can make sure that troubleshoot if there's any problems. For anyone who wasn't at the last webinar, I'll just give a quick recap of what we're doing and a few of the little bits and pieces. So what we're doing is we're giving some education to accountants about different areas of the law. Last quarter it was about changes in the building industry, and this quarter it's going to be more generally about companies and directors' responsibilities. And that came out of specific requests from accountant participants in the webinar who asked us to actually talk about these topics. So I hope everyone finds them informative. As I said earlier, we're doing these on a quarterly basis, and so if you'd like to sign up, just let us know and we can make sure that you receive the invites. And if you've got any questions during the webinar, please feel free to send Craig or I a message to the chat box and we can address them either as we're going, or if not, then we can always address them at the end if there's anything that's a bit more detailed. And also at the end of the presentation, if you've got any other questions, please feel free to email Craig or myself. Our email addresses are on this slide, and we can answer any questions that you've got. The presentation is also being recorded, but everyone else is on mute but us, so no one else has to worry about anything else. There'll also should be a short questionnaire at the end. So if we really value people's feedback to make sure that we're doing a good job. The topics are informative, so if you could fill that out, just take the couple of minutes just to do that, that would be greatly appreciated. Also, in the chat box, so you should get this, I'm going to share a Dropbox link. That Dropbox link links to a Dropbox that we've got with the seminar slides, which we're going to go through, a flyer about a promotion that we're going to offer everyone who attends this seminar to go to, and also just a brochure about Streten Masons Lawyers and what we do. Is anyone not able to see that brochure? Oh, sorry, that Dropbox link? No? Okay. Well, we'll kick on. If anyone's having any troubles, just send us a message and we can address that then. So for anyone who doesn't know Streten Masons Lawyers, Craig and I started the business back in 2011. We both came from a firm in Brisbane City where we were working together acting for small to medium-sized clients, and we decided that we wanted to go into our own thing and start our own firm. We specialise in acting for small to medium-sized businesses and their owners. We work really closely with accountants and our clients' accountants so that we know what kind of advice is being given and to make sure that everyone's on the same page. We've grown the business in the last 4 years from just Craig and I to a team of 12 full-time equivalents, and that's the team that you can see on the slide that's up at the moment. We work as a team, so we have 12 full-time staff, but everyone in both offices works together and everyone works really well. As I said before, we provide specialist advice to businesses throughout the legal life cycle, and yeah, with the two offices in Morningside and Caboolture, it means we can cover quite a lot of Southeast Queensland. So the key topics that we're going to talk about today is first, structures and trusts, and secondly, directors' responsibilities and penalties. I'm going to address structures and trusts, and Craig's going to talk about directors' responsibilities and penalties. So just to give an overview, in relation to the structures, I'm going to talk about the legal aspects of the structures. So obviously as accountants, a lot of what I'm going to talk about you're probably aware of, and if you're not, then it's good to get a refresher on some of these issues. But there's also the accounting aspects, which, as I said before, we work very closely with accountants, but we like to deal with both sides and make sure that the clients are getting the best advice. So the first structure is a sole trader. So a sole trader is exactly that. It's someone who operates the business in their own name. And it's actually the most common structure to operate a business in Australia, statistically speaking. From a legal point of view, however, it's actually the worst one that you could actually do. And the reason for that is that as the owner of the business in your own name, you're legally liable for everything. You're legally liable for all the debts of the company. If there's negligence in relation to the business, you're liable for that. The buck stops with you. From an accounting point of view as well, it's also not good because you can't distribute income. or anything like that. So whilst it's common, from a legal point of view, it's the one that we would recommend people avoid the most, and also the one that we try to get people out of the most, just because of that liability. The second structure that most of you will be aware of is a company, so a proprietary limited company. It's the second most common structure after a sole trader. And the great thing about a company is it's a separate legal entity. So from the legal point of view, it's separate from the people behind it, and it trades independently to the individual. I'm getting a message from someone that they can't hear us. Can anyone confirm that they can hear us? You can hear? Okay. All right. I'm not quite sure what, if they can't hear me, they probably can't hear the question. Okay. So, all right, we'll keep on going. Thanks very much, everyone. Yeah, with a company, it's a separate legal entity, and it trades independently of the individual. The two main roles in a company are the directors, and they're the ones who have the day-to-day management of the company, and the shareholders, and they're entitled to the income and capital of the company. So from a legal point of view, it's important to think about who these people are, and to ensure that those people are getting what they want and having the role they want. Because obviously, if you're a shareholder and not a director, you don't have any control over the day-to-day management of the company. So we often see people who have companies where there might be 50-50 shareholders and only one person's a director, and the other party can't actually do anything on a day-to-day level because they're not a director of the company. The whole thing about separate legal entities has also been eroded over time, I'd say, because most suppliers these days do require personal guarantees. They do, there's all the director's responsibilities that Craig's going to talk about, and but it has been watered down. But it's still the best protection that legally we can give clients to make sure that they're not going to suffer if something goes wrong with their company. The next most common entity is a discretionary and family trusts, and these are ones that they're obviously very popular. And again, it's a separate legal entity. Now, there's a number of different roles in a discretionary family trust. I'm just going to go through them from a legal point of view, because I think that it's important that everyone understands what the people's roles are in that trust. So the first is the trustee, and the trustee is the person or the entity that has the day-to-day control of the trust. And it's also the one that's primarily liable for the debts of the trust. And the reason for that is that from a legal point of view, a trust doesn't actually incur a debt. The trustee incurs a debt on behalf of the trust and is indemnified out of the trust assets. So what that means is if the trust doesn't have the money to pay back the trustee for the debts that it incurs on behalf of the trustee is left holding the bag. So that's the reason why, or one of the big reasons why, if we have a client who wants to use a trust for trading, that we always recommend that they have a corporate trustee to avoid that liability issue. The second role is the beneficiaries. So they're like the shareholders in a company, and they're entitled to the benefit and the capital of the trust. The third role is a settlor, and this is the independent third party that gives the first sum of money to the trust. It's usually the accountant or the lawyer that sets up the trust itself. Now, one thing that we see is people not paying that sum of money, and that can have disastrous consequences if it's ever found out, because the trust could be called a sham. So we always recommend that when setting up a trust, that you either give the first sum of money, it's usually $10, or you provide a check, or you do something to make sure that first sum of money is banked up. I personally tell my clients, I give them a check and I tell them to go and open a bank account and put that as the first sum of money, or if they're not going to open up a bank account, go and put it in a bank account with the trustee, because you can have commingled funds. The last role is the appointer or the principal. They both mean the same thing, and a trustee will give that person the power to remove and appoint a trustee. And that's the person with the real control of the trust, because they can kick out the person if they want him out of the trust, or they can basically control what the trustee does. So it's really important to understand all those roles and to make sure that our clients understand all those roles, because I've seen situations where, and this is I don't know why this was done this way, but two business partners, and each one had was the appointer of each other's trust. And that basically meant when there was a dispute, they could just appoint each other over the top of as trustee and have complete control over the trust. It just was not a good idea. And as you will well know, discretionary family trusts are great from a tax planning point of view. The next structure I'm going to talk about is unit trusts. Just like discretionary trusts, they're a trust. They have two roles though. They have a trustee, and they're, again, like a director, they have the day-to-day control of the trustee, of the trust. And the other role are the unit holders. And these are the beneficiaries of the trust and entitled to the income and capital. So often you might have say 4 unit holders, and they each own 25% in the trust, and they're all entitled to 25% of the income. We've found recently that unit trusts have gone a little bit out of vogue, especially with, they used to be set up for property developers buying a property. They set up a unit trust to buy the property, and each trust would own a separate portion of the unit trust. We've found that's going out of vogue, and people are doing that as a partnership of trusts. But it's still a good idea to have in place as just a unit trust for say, a trading entity. Once again, it's most preferable in this situation to have a corporate trustee, because like a discretionary trust, the corporate trustee can be, the trustee can be liable for the debts. And so you need to make sure you limit the liability for your clients. One thing to be very careful of with unit trusts is about 10 to 15 years ago, there was a case that said that unless the deed specifies otherwise, the members of the trust, the unit holders of the trust, are liable for the debts of the trust. And that can be overcome by a simple clause. Most trustees have those. Most unit trustees have those. So if you think that you have a trustee that may not have that clause like that, then either get a lawyer that you know, or even shoot it over to us to have a quick look at, just to make sure that that liability is limited, because we set up these entities to protect our clients, and every now and then you can have this problem of the liability being shifted away and the client losing that control. The next entity that I wanted to talk about is an unincorporated partnership. So this is usually where you've got two entities that don't want to set up a company or a unit trust structure, and it's governed by a partnership agreement. The problem with a partnership is the partners are primarily liable for all the debts of the partnership, jointly and severally. So you really need to make sure that if you are going to have a partnership, that the entities that are doing the trading are separate legal entities from the actual people behind it. Otherwise, they're going to have the issues of liability for themselves. We've seen, again, like with unit trusts, we've seen partnerships becoming a little bit less popular. People often, that we talk to, want companies instead of partnerships. Both are fine, but company just gives you that extra level of protection. The last entity that I'm going to talk about is self-managed super funds. So these are structures that have give the owner of the super fund some control over their money rather than being in a retail super fund. And they're governed by the rules in the Superannuation Industry Supervision Act and other legislation as well. Again, like the other trusts, there's two roles. You've got the trustee. Again, they've got the day-to-day control of the trust. And we really strongly recommend that a super fund trustee is a corporate trustee. That's mainly for protection of liability, but also for estate planning protections, because it's very hard to change an individual trustee if something happens to that individual trustee. The other entity would be the members, and they're the ones who get the beneficial interest in the trust, and they make contributions to the trust and receive the benefit of the money in there. As you will no doubt be aware, recent years they've been allowed to borrow money, self-managed super funds, so long as you follow certain rules. And yeah, that's been a great thing for people to be able to go out and do. It is a heavily regulated area, and it's also something that's subject to change on a regular basis. The government's always talking about changing superannuation laws, so we've also got to be careful when we're advising clients that they know that whilst it might be great now, things might change in the future. Just to finish off my slides, I just wanted to talk about and reiterate a little bit about the common mistakes that we see in structures. And this isn't just about accountants' structures, it's lawyers' structures, people doing them themselves. I'll just go through them briefly. If anyone's got any common mistakes that they see done with structures, please make a comment. I'm happy to share those with the group. Now, with the sole trader, the issue there is, as I talked about before, that the person is personally liable for the debt. So it really needs to be avoided at all costs. With a company, one of the big problems is that people don't take into account all the rules of the company, like the director's responsibilities. There's a question about, could you please provide some examples of where a director may be personally liable other than insolvent trading? The only time there would be if they sign a personal guarantee, or if there's a director's penalty notice that they haven't complied with, or something like that. It's usually directors are pretty well protected from that kind of thing. Also, they're also liable if they breach any of the director's duties, and Craig will talk about that shortly. Discretionary and family trusts. One of the big problems that we see is people just going and buying a generic trust deed that does not properly define who all the beneficiaries are. So as you know, with a discretionary family trust, usually it's set up so that all of the family members of a principal person are beneficiaries of that trust, and often they might exclude one type of person because of a drafting error or because they took it out of another precedent, like a husband and wife situation. So it's really important to make sure that everyone's included that wants to be included, because otherwise there can be tax implications if not. The other one that I alluded to before, common mistake, is not paying that initial sum, and the trust could be seen as a sham. There is a lot of people who don't do that, and it can be a massive problem. For a unit trust, believe it or not, probably the biggest issue that we see are people not completing the documentation properly. And I don't know how many times I've seen this where people come to us with a unit trust and it's not set up, it's not signed properly, it doesn't have the certificates actually appointing units to people. It's a real big problem, and people need to sit down and actually look at their structure and make sure it's all set up properly, because otherwise it's going to cause a lot of issues. Partnerships, the biggest issue here is not having a partnership agreement in place. So, a partnership agreement will set out all the rules of the partnership. It will set out, if it's properly drafted, should set out some exit clauses, should set up who's doing what in the partnership. People don't have partnerships agreements. Most partnerships don't have an agreement in place, and they really should, so that there's some rules governing what happens if things go bad. And the biggest problem that we see with superannuation funds is individual rather than corporate trustees. So unless anyone's got any other questions, that's it from me on corporate structures. Feel free to ask any other questions if they pop up while Craig's talking about directors' responsibilities, and I can answer them at the end.
Excellent. Good afternoon, everyone. As Jeremy said, this is Craig Mason talking about directors' responsibilities and penalties. Thank you, everyone, for coming along and listening to the webinar. As Jeremy said as well, if you've got any questions, feel free to ask them along the way. If not towards the end, or send us an email. So, directors' responsibilities and penalties. I'm going to go through 7 responsibilities and some of the penalties today. There's some are under common law and some are under the Corporations Act. The first one I wanted to talk about is the duty to act in good faith in the interest of the company as a whole. Now, generally, a director will breach this obligation if they're found to have subjectively, so in their own minds, failed to give proper consideration to the company's interests. There's then an objective standard that's applied to that, so it's the reasonable in the eyes of a bystander, whether an intelligent and honest person reasonably believed that the transaction was in the best interests of the company. So, relatively common sense duty. Whenever a director is doing anything, it's in the best interests of the company and not in the best interests of themselves as an individual. A director must consider the shareholders as a collective. However, in the case of insolvency, it's no longer the shareholders. They must also consider the creditors as well under that duty. So, as I said, relatively straightforward in the sense that it's a common sense duty. The other duty on that slide is a duty not to act for an improper purpose. Now, this duty or a breach of this duty normally occurs when a director uses their position and knowledge as a result of their position obviously as a director of the company, to attain advantages for themselves or defeat the voting power of the existing shareholders of the company. Now, important thing to note with that is that a director, in promoting the interests of a company, may also indirectly promote his or her interests, and that would not be a breach of that duty. If the actions of the director are to promote the interests of the company, and that's the sole purpose of the action, and they just happen to also promote their own interests within that as part of that, then they would not be breaching the duty not to act for an improper purpose. All right, next one is the duty to avoid conflicts of interest. Now, this is an obligation that a director must make informed and independent judgments on decisions relating to the company, and as such cannot put themselves in a position where their own personal interests may conflict with the best interests of the company. It may be direct or indirect. So an example of that might be that a director may not have a personal interest in a matter, but might be, say, a shareholder of another company that's dealing with that company of which they are a director of. So it could be they're choosing a particular supplier or some form of contract they might be getting into, and the director is also a shareholder of a supplier. In that instance, it would be a breach of the duty to avoid conflicts of interest, except there are two qualifications on that duty, and they are if it's expressly provided in the Constitution that a director may have a personal interest in a contract with the company. However, if there's going to be a vote on that, they still have to, that's the director, still has to vote in the best interest of the actual company, not in the best interest of the other company that might be entering into the agreement or where the director is a shareholder. The other qualification is if there's full disclosure, so the director discloses to everyone, yep, I'm a shareholder of this other company, and we're putting forward a tender for a project or whatever it might be. There's full disclosure, but there has to also be approval then as well. And it's got to be express approval. So full disclosure and express approval. If none of those qualifications are met, then the contract would be voidable by the company. So they'd be able to get out of it, provided the directors breach that duty to avoid conflict of interest. So relatively common sense, really. You would expect that a director would disclose any interest that they may be getting from a contract, and they would then expect that if there was a problem with that, they wouldn't go ahead with it. So there are two qualifications. Alrighty, so the next duty is the duty not to disclose confidential information. So obviously, often as a director, a person might become aware of a variety of information, and a lot of that information would be confidential. So the duty is to prevent a director from disclosing that information that's confidential to third parties. This obviously protects the interests of the company and prevents a director from abusing their position. Now, information will be considered to be confidential where the owner of that information reasonably believes that if disclosed, it would be detrimental to him or her or advantageous to others, that the information is confidential, secret, and not in the public domain, and that in the light of the industry or practice, the information will be regarded as worthy of protection. So an example of information that would probably be considered confidential would be, say, disclosing the details of all the company's clients or suppliers in such situations where that information was given in confidence, or engaging in some form of insider trading. So if you did any of those things, you'd be in breach of the duty not to disclose confidential information. Now they're the common law duties that I want to discuss. I'm now going to move on to the duties that are legislated in the Corporations Act. And the first one of those is section 182, and that's the duty not to make improper use of position. Now, obviously, a director must not use their position to gain an advantage for themselves or any other person or cause a detriment to the company. Contravention occurs when a director engages in conduct with the intention and purpose of gaining an advantage or causing detriment. And this is regardless of whether the benefit actually occurs. So if they're seen to be using their position improperly, but they don't actually obtain any benefit, then it's still a breach of that duty under section 182 of the Corporations Act. The next one is section 183 of the Corporations Act, which is duty not to make improper use of confidential information. Now in this one, in addition to confidential information, they must not use any other information improperly for their or someone else's gain or to the detriment of the company. Now, a case that was decided where the person was found to have breached this duty was the Steve Vizard matter. In that situation, Mr. Vizard was gained some information as director of Telstra. Based on that information that he obtained, he used that to make decisions to buy and also to sell shares in order, obviously, to obtain advantage for himself. He also set up a company that was doing the trading, so it was an advantage, obviously, for the company as well as himself. Now, in that situation, he was found to breach the duty under section 183. In the end, he ended up obtaining an advantage of about $140,000, and the court ordered that he pay the sum of $390,000 in fines. The maximum penalty for each breach, he had 3 breaches of the duty, was $200,000 for each breach. And as I said, he got $390,000 worth of fines, which obviously is quite substantial when you look at it in comparison to his advantage, which was $140,000. Also, under that section, you can be disqualified as a director for a period of time. ASIC in that case was actually saying 4 years, and the judge went against what ASIC were asking for, which is unusual, and disqualified him for 10 years from being a director of the company. So you can see from that that the punishment for that was substantial for obtaining an advantage of some $140,000. The last duty that most of you have probably heard of and is the most sort of one that's discussed in the public domain is the duty not to trade while insolvent. Now, this duty is to prevent a company from trading whilst insolvent and to continue to incur debts with third parties. So it can be proved if that a director has continued to trade a business whilst it was insolvent, then the director can be personally liable for the debts incurred by the company whilst it was insolvent. It also extends to if there was reasonable grounds to believe that by entering into a particular transaction, that was going to send the company into insolvency. So if they've got a suspicion that by doing a particular thing, entering into a particular contract, whatever it might be, that would bring the company into insolvency, then that would also be a breach of this duty. So the director needs to have reasonable grounds for suspecting insolvency or become aware, or a reasonable person will be aware, and then they obviously need to fail to prevent that transaction. Now, there are 2 types of trading whilst insolvent. There's the civil breach, which will involve monetary fines and compensation claims and disqualification from being a director. There's also a criminal component as well. If all of those things are done and the director has actually acted dishonestly, then it is open for criminal proceedings to be instituted against them. I've just got a question. Does this apply to a company solely as trustee of a trust? Well, yes. The directors of that company that are the trustee of a trust, these duties apply to those directors as well, in the same instance as anything else. Also, whilst talking about insolvency and other responsibilities that the director may have, we've just spoke about the insolvent trading compensation claims. In order for that to be instituted, the company has to be in liquidation. And in that instance, the liquidator has 6 years from the date of liquidation to bring a claim against the director. So it's quite some time. However, a director does have some defences to that. And the defence can be that they took all reasonable steps to avoid the event. It was reasonable to not believe the company was insolvent due to some reason, or due to illness or some other reason, the director simply wasn't involved in the company and was unaware what was happening. Obviously, with that, it's a tough one to prove because a director does have responsibilities to be aware of the financial position of the company and be actively involved. If they simply just didn't care and didn't look into things, it'd be unlikely that would be a defence to insolvent trading. So, as I said, 6 years, the liquidator can bring those claims for a compensation for the insolvent trading. A creditor can also bring those claims as well, and their compensation is capped at whatever their debt was or is. Sorry. So if they're owed $10,000, then their compensation claim can only be capped at 10, and there's all the costs and interests and everything involved in that as well with any other court proceedings. The other thing that may happen to a director, and again, the company must be in liquidation in this instance, is if there's been any unreasonable director-related transactions. In that situation, the liquidator can set aside transactions for a period of 4 years prior to the liquidation. So it's different to a preference payment, where the relation back period in that instance is 6 months from the date of liquidation. For an unreasonable director-related transaction, the liquidator has 4 years in which to set aside those transactions. And in terms of director-related, that obviously includes the director's family, it includes the director's spouse, and it also goes as far as to include the director's spouse's family as well. So any of those transactions that are done to defeat creditors or anything that's in the interest of the director and not the company, the liquidator has the 4 year period to set those aside. So that's obviously going to be conveyancing or some form of transfer of assets. The other thing that can come back against a director, again, has to be in liquidation, i.e. the company. If the director or the company makes any transactions during that period to avoid employee entitlements, then a liquidator can come after the director personally for those, if those transactions were done for the sole purpose of avoiding employee entitlements. Now that's different to the director's penalty notices, obviously, and those can be instituted against a director regardless of whether the company's in administration or not, which is the directory penalty notices. And as Jeremy said before, the other thing that can be a director can be personally liable for, regardless of whether the company's in some form of external administration, is personal guarantees. So any director that signs a personal guarantee, they are now liable for that debt, And most personal guarantees can be used by a creditor in any breach, and it could be a relatively minor one, and they can pursue the personal guarantor. And in most of them as well, they don't actually even have to pursue the company. They can go straight after the personal guarantor, which in most instances is going to be a director of the company. Again, depending on what the guarantee has included in it, that it may continue against the personal guarantor regardless of whether they're a director of that company, which obviously can be an ongoing liability for someone that's left a company and no longer a director. They need to take some steps to make sure that a new credit application or a new agreement or whatever it might be is signed by the company, and new personal guarantees are obviously signed. The creditor agrees to release the particular director that's leaving a company. We see that a lot where you don't know what personal guarantees you've signed as a director, and you head off and leave the company for whatever reason, and lo and behold, you've got people chasing you for personal guarantees that you signed some time ago that you thought would have been released upon you leaving. It's simply not the case. So we encourage anyone that signs personal guarantees to keep track of exactly what they're signing, because they are extremely important documents. Now that brings us to an end of the content that we were going to outline. If there's any questions, feel free to fire them over to us now. While you're doing that, I also wanted to just run through our next webinar, which is going to be on the Tuesday, the 24th of November at 1 o'clock. Now, this webinar is not just for accountants. We're giving this as an offer to everyone that's at the webinar today to share it with their clients or anyone else they may know. It's a webinar about making 2016 the best business year ever. And the way it's going to work is that we've developed what's called the business legal life cycle, which outlines a business life cycle from a legal point of view, right from conception to potentially retirement or insolvency or the winding up of the business. And the aim of the webinar is to run through that life cycle, and at the end of all of that, any attendees will be able to complete a questionnaire, meet with a solicitor from our office, and we'll pinpoint exactly where they're placed on the life cycle. And from our experience, we know that if you're at a particular stage, for instance, it might be that you've started up your company or business, you're trading, and you're now bringing on, say, initial clients. We know that at that stage, there's particular things that you need to do. We'll outline all of those, and then that person will know what they need to do. They can check off what has to be done. And they know that they're then met from a legal point of view, at least from our point of view, that everything for a business at that stage is now met. So it's on the 24th of November. We will share, or it's currently in, the flyer is currently in that Dropbox link that Jeremy sent through before. So please everyone check that out. There's a register now link on there. As I said, 24th of November at 1 o'clock.
There's been this is Jeremy Streten again, there's been one question about what happens if you cannot find a really old trust deed for a family discretionary trust. And this is a question that we do get quite a bit. The first thing to do is to really explore all of the options to try and find it, because it is a painful process to get a trust deed replaced. Looking back at old lawyers, accountants, anyone that they might have used, if you after going through that painstaking process you can't find it, the trust can adopt new trust terms. There can be consequences of that. It could be considered a resettlement of the trust. If roles change, if people are appointed as beneficiaries that aren't or weren't beneficiaries under the old deed, and you might ask, how would anyone know that? Well, if it popped up later on, that might be found out. So yes, you can, but you basically, yes, you can fix the problem if someone can't find a really old trust deed. And the way to fix that is to go and basically move a motion of the trust to to adopt a new trustee, but you really need to know who the trustees are and who all the roles are before you go and do that. Alternatively, you could just, and other times we've just wound down that trust from a legal point of view and an accounting point of view, and then just set up a brand new one to continue trading the business. But obviously there are tax and other consequences of that as well, and stamp duty if you're owns property. All right, any other questions? If not, as I said earlier, feel free to get in touch with Craig or myself. We're always happy to answer questions and help people through. As Craig said, the Best Year Ever webinar on the 24th of November, we're really excited about this and would like people to come back to us about what whether or not that they're able to make that. Thanks very much, and we look forward to having you at our next webinar.